specifically whether or not the factual allegations establish driving or physical control of a vehicle as required to meet the elements of DUI. The second issue that I will address is in response to the state's brief, whether or not an arrest warrant can be buttressed or bolstered by a search warrant, but also more specifically, as it is applied to Mr. Robb's case, whether or not there is any proof that it was buttressed and bolstered, which I do not think there is anything in the record to establish.
Mr. Fernstein?
Yes.
Fernstein? Do you practice before this court often?
I do not, Judge.
Okay. So one of the things that struck me about your brief was that when the state responded, they filed their principal brief. You did not file a reply brief. And the state, they are coming after your brief on multiple grounds. They're asking us to dismiss this claim. And so I understand that you're going to address some of those issues in argument today, but you only have 20 minutes.
Sure.
I just want to advise you in the future, you might want to consider filing a reply brief so that we can thoroughly consider your issues at argument instead of trying to address them later on.
Absolutely, Judge.
You may proceed.
Okay. As it applies to Mr. Robb's case, specifically with regards to the arrest warrant and the affidavit of complaint itself, there is no factual allegations within the affidavit of complaint for the arrest warrant to establish driving or physical control. The warrant only states that there was a call to a wreck, and then at some point after, police arrived on scene and met Mr. Robbs, who then was under investigation for DUI because he appeared impaired. However, there's no factual allegations to establish that upon arrival, Mr. Robbs was in the driver's seat. Upon arrival, Mr. Robbs' vehicle was involved in the wreck that the officer responded to. And specifically, when we look to the search warrant's affidavit of complaint, it specifically states that upon arrival, Mr. Robbs was sitting in the driver's seat and his vehicle was involved in the wreck. That specific factual allegations were necessary for the arrest warrant in this case to have enough factual allegations to assert
I'd ask
that
that you speak
essential.
to the certified question,
Okay.
because they're asking, the state's saying that we don't have jurisdiction.
Sure.
So could you tell us why we have jurisdiction based on the certified question?
Absolutely. So it meets all four elements that are required under Rule 37. Specifically, when we look to the four, the judgment or order reserving the question must include a statement of the question itself, which it does. The main issue, I guess, that the state mentions is the fact that according to State v. Preston, a 1988 case, we have a requirement within the certified question to address the reasoning why the trial court denied the motion in the first place. When reviewing State v. Preston, it does not add that additional requirement or element on the in order to meet Rule 37. Rather, State v. Preston specifically states, just like any appeal, that if it wasn't addressed by the trial court, it cannot be addressed on first impression in the appellate court. And so essentially, they are trying to add an additional element by stating that we have to provide the reasons that it was passed upon by the trial judge. But of course, this issue specifically is a de novo appeal. And so at that point, there's no reason for us to an appellant to have to argue for Rule 37 that it meets that requirement or the reason why the trial court denied the motion in the first place. All that is required is that the question must identify clearly the scope and limits of the legal issue presented, which specifically is mentioned in the certified question itself. And then after the questions that were presented to the trial court, the certified question specifically mentions the trial court denied this motion, and it was based on those grounds. So I do feel that we met the requirements of Rule 37. The judgment and order specifically reserved the question, and it reflects that it was reserved with the express consent of the state and the court, and it also reflects the defendant, the state, and the trial court all agree that the issue is dispositive. So it does meet all four elements to establish a certified question for this court to hear the issue.
Let me follow up on your certified question.
Sure.
Okay. This driving offense occurred, if I read the record right, in October of 2020.
Correct.
And there was the guy was charged and arrested, and there was an affidavit that was filed. Okay. was filed in General Sessions Court, correct?
Correct.
Okay. And it remained pending until September of the next year, 2021, just a few days short of 1 year.
Correct.
And it was dismissed, correct?
Correct.
And that was September 30th. So after September 30th, the next day, let's say October 1st, there was no pending charges against your client.
Correct.
And so then in February, the state filed a presentment with the grand jury.
Yes.
But there had been a period of time where there was no charge pending. So what was the authority of the state to indict, because the statute of limitations for DUI is 1 year.
Correct.
So what was the authority for the state to be able to indict some 16 months after the crime occurred? If there was nothing pending at the time they filed it and presented
Right.
it in the grand jury.
And that is exactly the issue that we presented to the trial court, in that if the arrest warrant was sufficient, then even if...
No, you're missing my question.
So-
Let me let you go ahead and explain that, and then
Okay.
I'm going to follow up.
So if the arrest warrant, hypothetically, if the arrest warrant was sufficient and stated all the essential elements of a DUI, at that point, even if it was dismissed because of failure to prosecute, the state then can present or indict or after the 1 year statute of limitations.
I don't think that's what the case law says. I think the case law says that when the charge was dismissed in General Sessions Court and there's nothing pending, then that means that there is there's nothing pending. And so if you file it more than a year after the crime occurred, then it's an invalid presentment, because the statute of limitations had already run, because when the original charge was dismissed, there was nothing pending, and now more than a year later, it's presented to the grand jury. Do you understand that to be the law also, that it has to be pending? And I don't think it makes any difference that the fact that the state in their presentment cited to the fact that the original charge was brought in October of 2020, the original charge had been dismissed. Am I making sense in my question?
You are. I was not the attorney who represented Mr. Robbs at the trial level, and so it was not addressed in the trial court.
Do you understand that
I do.
to be the law?
My understanding was that as long as the warrant itself was valid, that is enough for the defendant to then be able to be on notice that there are criminal charges against them, even if it's dismissed, as long as that warrant was valid.
He's missing.
But
Yeah.
Not so sure.
Okay.
But anyway, but that issue was never raised.
Correct.
With the trial judge. And so
Correct.
if that would have been a basis to dismiss the presentment because it had been more than a year and the original charge was no longer pending, that was not an issue addressed by the trial judge.
Correct.
And if it wasn't addressed by the trial judge, then it can't be in the certified question, and so therefore we may not have the authority to address it.
So I believe still, I mean, if the arrest warrant itself is deemed to be
Yeah.
invalid, then at that point, there still wouldn't be a basis within the statute of because the argument that we made in the trial court was that because the arrest warrant was not sufficient to put the defendant on notice and therefore allow the defendant appellant now to understand.
But even if it was,
Right.
you know, to just kind of take, because that's when I first read this, I thought this was a statute of limitations question, but it's a certified question that touches upon the statute of limitations.
Right.
And what Judge Montgomery is arguing is that there was no authority for the presentment to begin with because the statute of limitations had already been blown. Is that right? So that should have been the argument.
Right.
But it wasn't.
But I believe that this is an independent basis that can allow.
Absolutely. But
Correct.
he's, sure, it's an independent basis that you're having problems with.
Right.
So you can proceed with your argument.
And my understanding is that in a certified question, if there's another issue out there that's not addressed by the certified question, then we're prevented from addressing it.
We are.
Certified question.
And the only thing that I'll say, in addition to the fact that I'm here maybe once every 2 or 3 months, so I hadn't seen you, certified questions, and I think this is in our case law, it's and you again have already, fraught with peril is the language. You
Right.
weren't below. But again, that was another reason for you to file a reply brief addressing the state's dissection of the question, because that is exactly what the state is going to do, and then that is exactly what we are going to do, because that is what we are required to do under Preston and all the authority you just cited. Certified questions, you may as well, I've only seen maybe one successfully argued in my 16, 17 years on the bench. You may as well just do a bench trial.
Absolutely.
So you preserve, your issues, but you may proceed.
Okay. Again, I believe under the certified question that was presented, it is an independent basis that can allow this court to still reverse the trial court's decision in that, because it's still based on the statute of limitations. So if this is an independent reason why the state, in addition to the reason that Judge Montgomery, addressed, if it provides an independent reason for why the state did not sufficiently, present the case to the grand jury within the statute of limitations, that is still a basis for this court to reverse the trial court's decision, would be the appellant's argument. Because at that point, the state did not meet within the 12 months as required by the statute of limitations on a misdemeanor. And then I guess I'll go to the second issue as far as whether or not the arrest warrant can be buttressed or bolstered by an affidavit of complaint in a search warrant. First off, as the appellee and the state specifically, mentioned in their brief, they specifically actually address that and say, although this court has not squarely addressed the question of whether an affidavit used to obtain a search warrant may be considered in determining probable cause for an arrest warrant sought hours later, it has concluded that a magistrate may consider affidavit from 2 separate search warrants. So there is no law that allows an affidavit of complaint of an arrest warrant to be buttressed or bolstered specifically by an affidavit of complaint in a search warrant. And as it applies specifically to Mr. Robb's case, I believe the issue is that there's no proof in the record that shows that the arrest warrant was sought hours afterwards or before the search warrant. There is no timestamp on the arrest warrant for when the magistrate signed off on the arrest warrant, whereas there is a timestamp of 1:25 a.m. on October 6, 2022 for the search warrant. So if the search warrant and the affidavit for the search warrant was provided, an hour, 2 hours after the arrest warrant, or even 30 minutes or 20 minutes afterwards, it was not provided to the magistrate judge and taken into consideration to bolster the facts of the affidavit of complaint underlying the specific arrest warrant. And the advisory comments are very specific in Rule 3 that an arrest warrant is not just an administrative task just for a magistrate to sign off on. It has the same significance as a search warrant in the facts that are needed in a search warrant to put the defendant on notice of the issues that are being addressed or of why they are in court, facing criminal charges.
Isn't there a lot of case law out there where there were warrants upheld for probable cause that the driver, they didn't specifically say the driver was in the vehicle? I mean, I feel like there's a pretty big body of case law out there that addresses that, looking at all of the circumstances, there was enough, even though it didn't specifically say this driver was in the vehicle. Like, no other drivers around, and all of those issues of the circumstances.
Absolutely, and the state addresses 2 specific cases in their brief on that issue. I think the difference between Mr. Robb's case and the cases cited by the state and the issues that you just addressed is that in those cases, a trooper or an officer pulled over the vehicle and then determined that the person who they pulled over was then under the influence of alcohol. In this case, all it states is that there was a wreck, and then the officer responds to the wreck. And there are countless cases where individuals are outside of the vehicle waiting for police to arrive, or they're helped out of the vehicle. And so at that point, there is no factual allegations other than a conclusory allegation that an officer responded to a wreck, and then the individual was under the influence. Otherwise, any affidavit of complaint for an arrest warrant can simply state the defendant was driving a vehicle under the influence on a public road, but that's not what Rule 3 and Rule 4 require. Not just a legal conclusion as to driving or physical control a public road and under the influence, but specifically the essential facts that allow the state to, establish each of those elements of the offense. And so I believe that that's what Rule 3 and Rule 4 require. And as applied to Mr. Robb's case specifically, I do not believe that the affidavit of complaint of the arrest warrant meets that requirement. And even when we look to the search warrant, there are those very specific factual allegations within the search warrant that should have been in the arrest warrant. And because there is no proof in the record that the magistrate judge relied upon the affidavit of complaint of the search warrant to bolster or buttress the arrest warrant, I do not believe that it fits, the statute or the requirement under Rule 3 and Rule 4. And I have a minute left. I will add that to my rebuttal.
Thank you.
Thank you, Judge.
General Reddick.
May it please the court, Catherine Redding on behalf of the state. This court should dismiss the defendant's appeal because he has failed to properly reserve a certified question of law. As an initial matter, the defendant's certified question does not identify the scope of the issue and the limits of the issue reserved. First, it does not identify precisely the reason the defendant relied upon in the trial court to advance his motion to dismiss the indictment. Certainly, the special conditions section of the judgment of conviction discusses the essential fact of driving or physical control at length, but the question itself asks whether the affidavit supporting the arrest warrant sufficiently stated the essential facts necessary to establish probable cause of every element, including physical control. So under the precise language of the question, this court would have to consider every element of DUI and not just the element of driving or in physical control of a motor vehicle. Second, the certified question is silent as to the reasons the trial court relied upon in denying the motion to dismiss. And the state did not create this requirement. This is from the case law. And in fact, there is a fairly recent decision of this court that I cited in my brief that specifically talks about certified questions and the requirement that the trial court's reasons for denying the motion be laid out in there. Further, the question is not dispositive. Even if this court were to find that the affidavit of complaint that underlies the arrest warrant is insufficient, it could still find the arrest warrant valid given that the magistrate reviewed it shortly or within hours of reviewing the affidavit for the search warrant for the defendant's blood, which was significantly more detailed.
Let's speak to Judge Montgomery's point. Do we have a valid judgment? Because if we don't have a valid judgment, why are we talking about the certified question?
I understand.
Well, statute of limitations can be waived also.
Very true.
And so,
Just got saved by Judge Montgomery.
I'm not saying, if the defendant submits themselves to the court,
And a guilty plea could be perceived as waiver. Okay.
I don't know that. But on the other hand, would you agree with the point that I made initially, that the underlying charge that had been filed with the indictment at the time of the arrest was dismissed, okay, and by the time the case was done in presentment to the grand jury, more than a year had passed.
Yes.
So in that sense, the statute of limitations had run because the underlying charge that told the statute of limitations when the guy was arrested in October of 2020 no longer existed.
I'll confess it's been quite some time since I've looked into this particular
happen very
issue.
often.
No. And it's not encompassed by the limits of the defendant's certified question.
No questions. It's not in the stat. It's not in that.
Yes. The state's position would be that the arrest warrant is valid. So even if the defendant did plead guilty. If Your Honor would like supplemental briefing on the issue, I'd be happy to provide it. I'd hate to take a position here today and then go do my research.
It's okay. What I brought up is not in the certified question.
It is not. And the case law from this court is...
And since the trial judge was not asked to address it, why should you?
I think given the the limitations placed on certified questions and the requirements that the Tennessee Supreme Court and that this court has put in place, given that that is not encompassed by the certified question, I don't think that this court can get to it, even if it decides that it should not dismiss the case because the certified question is sufficient. It really it doesn't get there. And so I don't think that this court has the ability to consider that particular issue. So if this court does determine that the certified question that the defendant presented is sufficient, does preserve review of the particular question that he identifies in his certified question, he's not entitled to relief because the state did commence his prosecution within the statute of limitations. The defendant was arrested on October 5th, 2020. DUI, third offense, is a Class A misdemeanor, so it is a 1-year statute of limitations. So the state had until October 6, 2021. The state did not take that long. The state took 1 day. When the magistrate issued an arrest warrant the day after the offense. Contrary to the defendant's assertion, the arrest warrant was valid because the underlying affidavit was sufficient. Officer Holt stated in the affidavit that he responded to an injury arrest, that the defendant's breath smelled of alcohol, that his person smelled of alcohol, that he had bloodshot, watery eyes, slurred speech, was unsteady on his feet, all the standard observations that are extremely typical in DUI cases. He said in his affidavit that he wanted to conduct field sobriety tests, but that the defendant was uncooperative. He explained that he could not issue a citation to the defendant because the defendant was intoxicated and a danger to himself. He further stated that the defendant had a suspended license, no proof of insurance, and refused to voluntarily submit to a blood sample. As a result, this affidavit provided specific, reliable information from which the magistrate, reading the affidavit in a common sense way, could make an independent determination that a driving under the influence had occurred and that the defendant was the one who had committed this offense. And I've pointed this court to Pace and Osborne, and both of those cases are similar. I think they provide guidance to this court about what is necessary in an affidavit of complaint underlying a DUI arrest warrant. And when you look at those in a common sense manner, the gap that's missing, the defendant was sitting in the driver's seat. I saw the defendant driving. This court, and I believe the Tennessee Supreme Court, but at least this court on multiple occasions has found that when you read the affidavits in a common sense manner, that you can make that connection, and that is enough for probable cause. But even if the affidavit underlying the arrest warrant was not enough on its own, it is the state's position that it could be buttressed with the affidavit of complaint offered in support of the search warrant, which the magistrate saw the same morning that it saw the affidavit in support of the arrest warrant. And that affidavit was far more detailed, placed the defendant in the driver's seat. There's no issues there. The Advisory Commission said for Rule 4, Tennessee Rule of Criminal Procedure Rule 4, that an affidavit of complaint may be buttressed by additional affidavits. This court, as my friend on the other side noted, it's the state's position that this court has not actually addressed this particular issue before in terms of a search warrant and an arrest warrant and how the affidavits between those two warrants work together. But it has considered affidavits for 2 search warrants in State v. Smith, and it has found that a magistrate can consider the affidavits for both warrants. And this is consistent with cases, federal cases, the Sixth Circuit, and State v. Nolan, United States v. Nolan, and United States versus Manufacturers National Bank of Detroit, which I've discussed in my brief. Those both provide guidance. One of them dealt with affidavits that were submitted simultaneously. The other one said that it was okay for a magistrate to consider affidavits that were provided a day apart. And so given the case law, yes, this court hasn't decided this question before, and in Smith it was dealing with 2 search warrants, but that does not mean that the same analysis doesn't apply for a search warrant plus an arrest warrant. So given the case law from this court and the case law from the Sixth Circuit kind of discusses affidavits and how affidavits from different warrants can be considered together, it's the state's position that here the affidavit of complaint for the arrest warrant can be considered buttressed by the affidavit for the search warrant. And when you take the 2 of those together, given that they were presented to the magistrate on the same morning that she had the affidavit for the blood warrant, or the blood search the more detailed affidavit first, before she got to the affidavit for the arrest warrant, that when you look at them together, it is clear that they establish every essential fact of DUI, including that the defendant was in control, driving or in physical control of the vehicle. And because the state initiated its prosecution within the statute of limitations, the defendant's not entitled to relief. So, unless this court has any further questions, the state asks this court to dismiss the defendant's appeal or, in the alternative, affirm the judgment of the trial court. Thank you.
General Redding. You have your rebuttal time.
So just going off what the state just said as far as buttressing the arrest warrant with the search warrant, again, the two cases cited by the state, one is where they were both two different separate search warrants were provided to the magistrate simultaneously. The other is where there was a second search warrant within some time period afterwards, but the magistrate judge was able to rely upon that first search warrant to buttress or bolster the second one. There is nothing in the record to establish that the search warrant was signed by the magistrate judge, and therefore the judge reviewed the affidavit of complaint prior to the reviewing and signing the arrest warrant.
Is the
based
warrant not in the record showing who signed it?
So it's the same magistrate, but there's no timestamp on the arrest warrant for what time the arrest warrant was signed. There is a timestamp of 1:05 a.m. Specifically for the search warrant, but there's no timestamp on the arrest warrant, so there's no proof that the magistrate judge actually relied upon the affidavit of complaint for the search warrant to buttress or bolster that arrest
They're both
warrant.
dated.
They are dated the same date, but there's no proof as far as which one was signed first, and therefore, if the search warrant was signed after the arrest warrant, then it didn't bolster or buttress the arrest warrant to provide the magistrate with the additional information to prove driving or physical control to allow the magistrate judge to rely upon that information before signing off on the arrest warrant. So if the judge signed the arrest warrant prior to receiving the search warrant and the affidavit, that was in support of that search warrant, then it wasn't bolstered at all, would be the appellant's argument here. And then going back to the certified question and the statute of limitations, and again, I can provide the court with a supplement if it would be necessary, but I believe in the motion to dismiss that was provided at the trial court level, I believe that as long as the state, commences prosecution within that year, which they did through the arrest warrant, even if it is dismissed after the fact, after the year, the state can still save or cure it by then filing a presentment and bringing the presentment forward after the year. And so that's why this specific certified question is related to the other reason why the state did not meet the statute of limitations. I believe the case law specifically states that if the arrest warrant was invalid, then prosecution was not commenced within the statute of limitations. And so that's the appellant's argument, is that because the arrest warrant wasn't sufficient and therefore wasn't filed within the 12 months for the statute of limitations on a misdemeanor, at that point, they did not, meet the statute of limitations on a misdemeanor to proceed forward with the presentment. If that arrest warrant was valid, then they would have met the statute of limitations. But because they did not, because the essential facts, of each of the elements were not provided for, at that point they did not meet the statute of limitations, and the appellant asked this court to reverse the trial court's decision and dismiss the presentment against the defendant.
Thank you, counsel.
Thank you, Judge.
The matter will be taken under advisement. We appreciate both of you, your arguments and your briefs. Madam Clerk, does that conclude the morning docket? All right, we'll be in recess until 1:30.
All right. This court will stand in recess.